Welcome to the Consumer Financial Protection Bureau's meeting of its Credit Union Advisory Council, or CUAC. The Consumer Financial Protection Bureau is an independent federal agency whose mission is to help consumer finance markets work by making rules more effective, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. My name is Delicia Hand, and I'm the Staff Director for the Advisory Board and Council's Office in the Division of External Affairs at the CFPB. Today's meeting is being held at the CFPB's headquarters in Washington, D.C. This is the CUAC's second meeting of the year, and as always, we have a packed schedule. Today's meeting is being live streamed on consumerfinance.gov, and a recording will be made available on the CFPB's website. You can also follow the CFPB on Twitter and Facebook. Let me spend a few minutes telling you what you can expect at today's meeting. First, I'll introduce the Bureau's CUAC members. Then the CFPB's Director, Richard Cordray, will provide opening remarks. Following the Director's remarks, the CUAC Chair, Robin Romano, will conduct the meeting. Chair Romano will then introduce Sunaina Lahill and Yannicka Ratcliffe, subject matter experts with the Bureau's Office of Financial Education. The two will lead a discussion on youth financial capability. Following this discussion, the CUAC will then hear from Kristen McPartland and John McNamara, subject matter experts within the Bureau's Division of Research, Markets, and Regulation. The two will lead a discussion about debt collection. The meeting will then adjourn at approximately 5 p.m. The Bureau established a Credit Union Advisory Council to include representatives of credit unions from across the United States. The CUAC is charged with providing substantive information, analysis, operational expertise, knowledge of their communities, and feedback to inform the Bureau's work. Today's public meeting and discussion is in support of this important mission. As a reminder, the views of the CUAC members are their own. They are greatly appreciated and welcome, yet they do not represent the views of the CFPB. So let's get started with an introduction of our CUAC members. The chair is Robin Romano. Robin is CEO of Marisol Federal Credit Union, a CDFI credit union in Phoenix, Arizona. Carrie O'Connor is Chief Lending Officer for Community America Credit Union in Lenexa, Kansas. Gail DeBoer is President and CEO of SAC Federal Credit Union in Papillion, Nebraska. Gregory W. Higgins is Senior Vice President, Chief Administrative Officer, and General Counsel of Wings Financial Credit Union in Apple Valley, Minnesota. James Jim Spradlin is President and CEO of Park Community Credit Union in Louisville, Kentucky. Katie Prefke is Assistant Vice President and Compliance Officer for Chevron Federal Credit Union in Oakland, California. Robert Bob Donnelly is Executive Vice President of Members Credit Union in Winston-Salem, North Carolina. Thomas O'Shea is President and CEO of Aspire Federal Credit Union in Clark, New Jersey. Deatra Matthews is Senior Vice President of Legal and Compliance at the Local Government Federal Credit Union in Raleigh, North Carolina. Amy Nelson is CEO of Point West Credit Union in Portland, Oregon. Daniel Berry is CEO of Duke University Federal Credit Union in Durham, North Carolina. Faith Yeva Anderson is Senior Vice President and General Counsel at American Airlines Federal Credit Union in Fort Worth, Texas. Patrick Harrigan is Chief Risk Officer and General Counsel at Service Credit Union in Portsmouth, New Hampshire. Raynor Zilgit is Vice President of Risk Management and General Counsel at Lake Trust Credit Union in Brighton, Michigan. Ricardo Ledesma is Corporate Compliance Assurance Manager at San Antonio Federal Credit Union in San Antonio, Texas. Sarah Marshall is CEO of Northside Community Federal Credit Union in Chicago, Illinois. I'm now pleased to introduce Richard Cordray. Prior to his current role as the CFPB's first director, he led the CFPB's enforcement office. Before that, he served on the front lines of consumer protection as Ohio's Attorney General. In this role, he recovered more than $2 billion for Ohio's retirees, investors, and business owners, and took major steps to help protect its consumers from fraudulent foreclosures and financial predators. Before serving as Attorney General, he also served as Ohio State Representative, Ohio Treasurer, and Franklin County Treasurer. Director Cordray?
Thank you, Delisha. As usual, I have too many books to carry around. My folks are familiar with that phenomenon. And I'd like to start by welcoming everyone, both here and those who may be looking in from around the country, to this gathering of the Credit Union Advisory Council. And it's good to see all of you, including our members of the council here. We're here to talk today about promoting financial education among consumers, especially younger ones, and about our new proposed rule on debt collection. We look forward to hearing your thoughts and concerns as we discuss these and other issues. I especially want to welcome our newest members of the council, joining us for the first time since they were appointed. We all thank Robin Romano for taking on the role as chair and David Seeley for agreeing to serve as vice chair. I look forward to continuing our helpful dialogue and seeing what we can accomplish together. And today was another example of robust dialogue and new thoughts and insights. As the director of the Consumer Financial Protection Bureau, I've seen firsthand the important role that credit unions play in the lives of so many consumers and communities around the country. You take your responsibilities to your members very seriously, and many of you have been pace setters as consumer educators. Your voice matters, and we want to hear from you. In fact, we formed this council to learn more about how credit unions operate day to day and to hear about the current challenges you face along with your members. This helps us do better work. And we've learned from our conversations that we share many goals in common, most notably the goals of supporting consumers by providing fair treatment and excellent service. Take financial education, for instance, as one particular focus. Many credit unions have shown a broad commitment to promoting financial literacy and financial capability in the classroom. They've done this through programs presented both online and on cable access television. Some offer much-needed credit counseling to lower-income members. We heard a little bit about that today. In a variety of ways, credit unions arm consumers with the right tools to build their own financial capability to meet their individual and family needs. At the Consumer Bureau, we want to learn more about how these efforts and many others are helping to boost America's financial IQ. One way we try to assess these issues is through the National Financial Capability Study, which is an annual survey of the American people's financial wherewithal conducted by the Financial Industry Regulatory Authority, known as FINRA. This survey data gives a snapshot of the obstacles and opportunities that consumers face in their daily financial lives as they strive for longer-term financial goals. Today, we want to share how the latest findings can inform and influence our work as we seek to strengthen the financial capability of all consumers. We're pleased to say that this year's survey shows we're moving in the right direction. 7 years after the first FINRA study was conducted, Americans, on average, are experiencing less financial stress and more satisfaction with their financial condition. We also find the FINRA study especially useful because it discusses financial well-being along the lines of research we have done here at the Consumer Bureau. In our research, we heard from consumers and financial educators who identified 4 key elements of financial well-being. So now we're able to assess how we're doing on each of these 4 elements based on the results of the survey data in the FINRA study. On the first element, consumers have told us that their financial well-being depends on a sense of financial security that is provided by feeling in control of their finances both day to day and month to month. The FINRA study found that people are generally feeling more financially secure, although almost half still reported some trouble in covering expenses and paying bills. The second element looked at the ability to absorb an unexpected financial shock and whether people have a safety net in place for emergencies. This year's study showed that now, for the first time since its original publication in 2009, nearly half of Americans have an emergency fund they have set aside to cover 3 months of expenses. The third element of financial well-being that consumers reported was a sense of being on track to meet their financial goals. This year, the FINRA study found that those who report working toward long-term goals are much more likely to be satisfied with their personal finances than those who are not doing so. The fourth and final element of financial well-being consumers identified to us is the financial freedom to make choices that allow them to enjoy life in the moment. That could mean taking a vacation, for example, or simply going out to eat. We were encouraged that the number of people who answered the survey and said they're highly satisfied with their financial condition. That number has roughly doubled since 2009, and it now exceeds 30%. So that is the good news. But the results also reveal that large swaths of our society continue to face financial difficulties. More than half of all respondents did not have 3 months of emergency savings, and more than a third said they likely would not have enough money to cover an unexpected expense of $2,000. Individuals from several groups in particular reported their financial conditions are especially fragile. These include young people, women, African Americans, and Hispanics, as well as lower income and less educated respondents. Clearly, we have more to do to increase overall financial well-being and capability among all Americans, and we all play a part. As we continue to rise from the ashes of the financial crisis, we need to empower people to take more control of their economic lives. When more people have more financial capability, consumers and industry both benefit, and our economy rests on stronger and more enduring foundations. But financial education goes beyond just preaching the basics of financial literacy. It also means meeting people where they are, at work and in their communities, with the information and support they need, when they need it, and in ways they can understand and act on. It means starting early by helping parents talk to their children about the importance of money, proper saving, and spending habits. And it means giving young people access to the building blocks of financial capability in schools through curricula that engages them to learn and understand. Organizations and policy leaders like you are in position to help shape priorities and strategies to help the next generation achieve financial capability. And the Consumer Bureau now has new tools at the ready. They can help you refine existing programs and financial education resources, develop and test new strategies, and make better decisions to target resources on how to advance financial education. With this being Back to School Month, today is September 1st, we have some upcoming events of note, including a Reality Fair financial education event in Dallas, Texas, with the Credit Union of Dallas on September 7th, with a financial education town hall afterward, the FinEx convention here at our Washington office the next day on the 8th, and the launch of a Spanish language website for the Money as You Grow initiative and the release of a related parent guide around the middle of the month. And we soon will have still more to report on new and improved approaches to educating our young people on financial matters, so stay tuned. During this meeting, we'd like your input on these and other issues that you raised in our joint work on financial education. We want to know how we can work more effectively with the Council and other credit unions to foster youth financial capability. We ask you to share your ideas on how we can get the word out through credit unions and their networks, and how we can encourage more credit unions to utilize our financial education resources without having to reinvent the wheel. They're all available, not copyrighted, available for use on consumerfinance.gov. We see credit unions, like libraries, as effective partners in this work, and we want to know how we can make progress together to help people improve this crucial aspect of their lives. When people have the tools and resources they need to make informed financial decisions, it means they have more security as consumers. The FINRA study on financial capability tells us our collective efforts to educate and empower consumers can be working, and we need to stay the course and expand our activity to reach more Americans. We look forward to our continued work with all of you in this area to help more consumers reach their personal financial goals. Another important topic to continue to discuss with you is our new proposal to overhaul the debt collection market. Federal law already prohibits debt collectors from harassing, oppressing, or abusing consumers. The main law that governs the industry and protects consumers is the Fair Debt Collection Practices Act, which was enacted in 1977, almost 40 years ago. In 2010, the Dodd-Frank Wall Street Reform and Consumer Protection Act revised that law, making the Bureau the first agency with the power to issue substantive rules under the statute. In July, we announced that we have a proposal under consideration that would update federal standards on debt collection, consistent with changes in technology, and to help clear up decades of court rulings that have disagreed with one another in various respects. Under our proposal, debt collectors would need to have more and more reliable information about the debt before they collect. As they are collecting, they would have to limit their attempts to make contact, clearly disclose details about the debt, and make it easier to dispute the debt. When responding to disputes, they would not be able to pursue collection without sufficient evidence. These conditions and restrictions would apply as well if the debt is sold or transferred. Our goal is to bring more accuracy and accountability to a market that desperately needs it. We're at the early stages of considering different aspects of this proposal, which is a good time to be discussing it. Debt collection, in fact, generates more complaints to the Consumer Bureau than any other financial product or service. The same has long been true at all levels of government, federal as well as state, around the country. We've fielded complaints about collectors seeking to collect debt from the wrong consumer, for the wrong amount, or that could not legally be enforced. And when consumers are contacted by collectors for debt they do not recognize, they often do not know where to turn. Some feel pressure to resolve the debt without a clear understanding of their rights. Some pay a debt they think is wrong just to get the collector off their back. Other times, consumers spend significant time and money trying to dispute the debt, often in the face of unnecessary obstacles, simply because they have not carried all their personal records with them through all the years of their lives. According to the preliminary results of a survey we conducted, about 1 out of 3 consumers has been contacted by a creditor or collector trying to collect a debt within the past year. That is roughly 70 million consumers. That's an enormous number. And it's a figure of special concern in the wake of the damage done by the financial crisis. Many consumers who were contacted report that they were being pursued on multiple debts, between 2 and 4 debts for most of the consumers, as noted in our report of preliminary results. And fully 1/3 of the consumers who had been contacted about a debt in the last year reported that they believed the collector was trying to collect the wrong amount. Debt collection is a multi-billion-dollar industry with estimates of over 6,000 debt collection firms in the United States. Some of these firms are given inaccurate or incomplete information when they are hired or when they purchase debt to collect. They may also add errors of their own through sloppy procedures, and they may compound the harm to consumers by failing to provide sufficient information during the collection process. That leads to more disputes and more problems during collections, and it's a recipe for consumer harm. These factors also drive up costs to collectors, which hurts the industry as a whole. When an account is sold or moved, the information that transfers may be only the information that benefits the collector, rather than information that also benefits the consumer. That creates further problems as well. The proposal we have under consideration right now would overhaul the entire process from the moment third-party collectors first receive their debt portfolios to their very last efforts to collect on these debts. The proposal also covers many debt buyers, and as part of our work in this area, we plan to address issues with first-party debt creditors on a separate track. Last month, we held a field hearing on these issues in Sacramento, California, and last week we convened a small business review panel to gather feedback from small industry players. While we digest that feedback, we will continue to seek input from the public, consumer groups, industry, and other stakeholders as we proceed with the rulemaking process. This is not our first foray into the debt collection marketplace. In October of 2012, we issued a rule establishing our supervisory authority over non-bank debt collectors with more than $10 million annually in consumer debt collection receipts. This covers some 175 debt collectors, accounting for more than 60% of the market, and it was the first time the federal government had ever asserted supervisory authority over debt collectors. We also have enforcement authority, which we share with the Federal Trade Commission and state attorneys general. Ever since we opened our doors, we've worked together in a group effort to police unlawful practices in the industry. Both on our own and with these partners, the Consumer Bureau has exercised its authority to order companies to halt violations of federal law and make them refund hundreds of millions of dollars they had unlawfully collected from consumers. All of that experience creates a strong foundation for us now to proceed with our rulemaking to reform the debt collection market. Ogden Nash wrote much lighthearted verse, but not always with lighthearted messages. As he accurately noted, some debts are fun when you are acquiring them, but none are fun when you set about retiring them. Give you a moment to let that sink in. Debt can overwhelm people and leave them feeling helpless and powerless in trying to fend off harassing debt collectors. By cleaning up the integrity of this process, we can resolve many issues before they become problems. And with better financial education for our young people, we can head off some of these issues in the first place by putting them on a surer path toward financial security. So thank you all, and I look forward to our discussion today.
Thank you, Director Cardre. So now it's my turn to welcome everyone to the second meeting of 2016 of the CFPB's Credit Union Advisory Council. My name again is Robin Romano, and I'm the chair this year for the Credit Union Advisory Council. I'd like to welcome members of the public, as well as existing members of the council and our brand new members of the council. CFPB organized this council in 2012 as a means to hear regularly from credit unions from all over the country. Since I've been a part of this council, I've observed, I've participated in, and believe this to be a very productive exercise. Conversations have been fruitful, they've been passionate, and the CFPB gives us an opportunity to share our perspectives on emerging issues facing us, facing our industry, and give perspectives to the Bureau's Bureau staff and directly to Director Cordray. We share a mutual value of wanting to protect consumers. So today, this afternoon, we're going to hear from council members on two issues. Approaches for helping young people achieve financial capability, something that I think is near and dear to everybody at this table's hearts, as well as learning about the Bureau's recent debt collection proposal and giving feedback regarding that. So first, we're going to hear from the CFPB staff. Yannicka Radcliffe and Sunenu Lahill, who will serve as the Bureau's experts on financial education. Then we're going to shift over to a discussion to the council members regarding to gain their perspectives on some of the key issues for credit unions and where the CFPB ought to be focusing its attention on this space. During that time, I'll ask council members to share their thoughts, their opinions, as well as ask questions on these important topics. So now I'd like to invite Yannicka Radcliffe to come up. She is the director of the Office of Financial Education, and Sunenu Leahy, who is the K-12 Senior Policy and Innovation Analyst for the Office of Financial Education, to share with us the Bureau's recent activity and research in youth financial literacy and capability.
Thank you, Robin. My name is Sunena Lahill, and I am here to talk to you about what we're doing to support financial capability for children and youth. As the director mentioned, it's back to school month, and with that, we are really kicking off today a series of events and activities to really highlight the importance of financial education, particularly targeted at children and youth. For some of the council members who are here and were here last year, some of the things that I will talk about may be familiar to you, as my colleagues from the Office of Financial Education presented to this council about our work in the adult space, what we're doing to support financial capability for adults. So I think there will be some research and particularly resources that may look familiar to you. Given our mutually shared goals here with credit unions and the Bureau around financial capability and financial literacy for youth. I'm particularly looking forward to the discussion and to hear about your ideas on how we can work together in particular areas where really there are synergies for us to be collaborating and coordinating efforts. So I look forward to your thoughts and ideas. So my presentation today will touch on 3 themes. First, I will talk about the current financial education landscape. I will touch on how we're supporting financial education in that landscape to advance financial capability for children and youth, and also highlight some research-based insights. And then from there, we can go into the discussion. There we go. As I imagine many of us can agree, many young people are transitioning to adulthood really not prepared for the financial challenges, decisions that they will encounter. And with that, when we look at survey results about how people feel about financial literacy, we find that there is strong demand for financial education. 89% of Americans tell us that they believe that financial education should be taught in schools. Family financial concerns are a common source of stress for many teens. And 89% of teachers believe that financial education should be taught in school. They see this as being something that's valuable. There's also promising evidence pointing to what is working in financial education. A FINRA Foundation study finds that high school financial education course is linked with improved credit scores as well as lower probability of delinquencies later in life. The study indicates that these results are seen in states that have strong financial education requirements as well as rigorous implementation focus. And evidence from Brazil's financial education, comprehensive financial education program found that financial education led to overall improvements in student outcomes. Among students who received financial education, they saw a reduction in overall grade failure rates for both high-achieving as well as low-achieving students. So not only can financial education be really critical to helping them prepare in life, but there's some evidence that it can also help make financial education more relevant and engaging to young people. And over the past decade here in the United States, there has been sort of a small but growing number of states who are enacting laws to require financial education in schools. So the slide that you're looking at here today provides some data points on that. So we know that currently 17 states require a high school course to be taken in order to graduate. 22 states require schools to offer a course as an elective. So schools are required to offer it, but students can decide whether to take it or not. And 37 states have standards that are required to be implemented. So, I think there is a promising sort of turn for recognizing the importance of financial education and more efforts. We're seeing more and more efforts to support that in the school. Recognizing that this demand for financial education, as well as sort of the range of stakeholders that are working to support financial education, including credit unions, nonprofit organizations, governments, whether at the state or local level, there is really a wide range of stakeholders that are supporting these efforts on the ground. And so the way that we really see our role here at the Bureau to support financial education is looking to support those stakeholders on the ground. What can we do to help those who are working to advance financial education, whether that's increasing opportunities or to improve the quality of financial education that's being delivered? And by pursuing this dual goal, we really think that we can make sure that children and youth are transitioning into adulthood really ready to make the financial decisions and the types of encounters that they will have. We're working particularly in 3 areas where we think we can have the sort of greatest impact. We are supporting education leaders who are seeking to implement policies that give youth opportunities to build financial capability, and I'll provide some examples of that. We are supporting practitioners by focusing on increasing their capacity to deliver high-quality financial education, and we are also engaging and empowering parents and caregivers so that they can support their child's financial development in the home. When we talk to the range of stakeholders that are operating in this field, whether they're policymakers, community leaders, or financial educators, there's a common theme. Many of them tell us that they are looking for what's working, what are evidence-informed or evidence-based practices for supporting financial education. And we think that this is an area where we can play a role and we can really support. And so I'll talk a little bit about some of the research that we're doing. So for the council members who were here last year, you may have heard my colleagues talk about the financial well-being research we've done in the adult space. So I'll describe a little bit of that. So the Bureau created a first ever consumer-driven definition of financial well-being, as well as a measurement scale to quantify changes in individual financial well-being over time. Prior to this research, a standard definition of financial well-being did not exist, even though there has been sort of an emerging consensus that that is the ultimate goal of financial literacy programs. And so what we learned from that adult-focused research is that there are 4 elements of financial well-being, and you can see that in the slide. The first is that financial security in the present. This element focuses on whether consumers feel they have control over their day-to-day and month-to-month finances. Financial security in the future, so this element focuses on whether consumers feel they have the capacity to absorb a financial shock. Financial freedom of choice in the present, and so this is really touching on the element where consumers feel they have the ability to make choices that allow them to enjoy life. And the fourth element is financial freedom in the future, which focuses on whether consumers feel they are on track to meet their longer-term financial goals. Building on that work to define and measure financial well-being, we're doing further research to understand what the developmental roots are of financial well-being. So we're doing research to understand when, where, and how children and youth develop the building blocks that really support financial capability and financial well-being later in life. And we'll have some results from this research to share with you all soon. But we really think that what we're uncovering here will help financial educators to support financial capability in ways that are not only developmentally appropriate, but also evidence-based. So this next slide highlights just some of the resources that are currently available to financial educators in this space, and I'm actually going to work from the bottom up, so because I will talk a little bit more in detail about the first 2 bullets. Money as You Grow is a resource that we've developed. It's a suite of tools that are available to parents and caregivers, and it's something that they can use to have money conversations at home with their children so that they can be taking an active role in supporting their children's financial development. And much of the resources that you'll find there are intended to be something that parents can incorporate into day-to-day activities that they are already doing with their children, as opposed to as something in addition to what they're doing. The Youth Financial Education Curriculum Review Tool is a resource that we published last year, and it's a resource that education decision makers, teachers, curriculum developers can use to identify and select curriculum that really meets their needs and that is sort of based on evidence-based best practices. This is a resource that's also available to those who are developing curriculum or developing classroom resources and want to know what are some areas for further development, what are others doing in this space that I should be thinking about. So it's a resource that can work for both curriculum developers, but also those who are in a position to decide what they should be using in a classroom setting. Transforming the Financial Lives of a Generation of Young Americans is a report that we published that really highlights some strategies that we think are really promising for advancing financial education in schools and in communities. And Advancing K-12 Financial Education, a guide for policymakers, is another resource that we've created specifically targeted at community and policy leaders who want to be doing more to advance financial education in their communities or in their states. So I'll talk a little bit more specifically about the first two resources. Recognizing the tremendous impact that we know that policy and community leaders can have on expanding financial education for youth, we really wanted to know what we can do here at the Bureau to support those efforts. And when we talked to policy community leaders, they told us a couple of things. They said that high-quality resources were really hard to find or they were limited. They also let us know that policy and programmatic successes where they are happening are often trapped in silos, whether that's geographic or sort of in terms of a particular field. And this is resulting in sort of a general lack of awareness about what others are doing across the country. And the third is that leaders working towards similar goals, they felt like they didn't have the opportunity to learn from one another as well as share best practices. And so based on these insights, CFPB published last year a resource guide for policymakers. And I'll give you a quick preview or overview of what that resource guide looks like. So in this slide, you're looking at sort of the modular framework that you would find in the resource guide. And we really took this modular approach because we recognize that not all communities are in the same place. Everyone is at a different sort of place in the continuum for supporting financial education. And based on that, we wanted something that anyone can use and they can sort of figure out where they are and find ideas, resources, and insights. So in the resource guide, we have case studies that highlight what's been working and successful in states. And we also have resources there that provide some examples of potential organizations or groups that are out there who are currently doing that particular work. So the framework for the resource guide, there's sort of three sections. One is laying the groundwork. And so this is for those who are maybe in the starting point, that you need help making the case for financial education. You want to know what kind of research to cite. You are looking to develop the strategy, and you want to know what other states have done. And you want to look at partnership opportunities. What have been some partnership models that's worked. On the building the initiative section, this is for those who, maybe some of that early sort of ground building work is already done, but you're looking at how to support teacher training, what kinds of classroom resources are available. So that's where you would plug in. And then the extending the impact is for those who, maybe have already launched and implemented a financial education initiative, but you're looking for ways to expand and build on that earlier success. And so that's sort of gives you a preview of the framework in the Policymaker Resource Guide. In the next couple slides, I want to talk to you about the Transforming the Financial Lives of a Generation of Young Americans. This is a report that we published when we really launched our youth financial education work to stress how important we think financial education is for children and youth and what we think are some really promising and exciting strategies for doing that. And so some of the themes that you will find in that resource is emphasizing how important it is for financial education to start early and build on that consistently throughout a child's development. Exploring and describing the range of experiential learning opportunities that are currently at work and stressing the importance of combining financial education or financial literacy with experiential learning opportunities, the importance of supporting teacher training, and encouraging supporting parents and guardians to discuss money management topics at home, recognizing that yes, financial education is important, it should be part of the school day, but there's also an opportunity for that to be supported in the home as well as outside of the home in community settings. So one particular insight that we've learned from our youth research that I mentioned earlier and continues to sort of reinforce for us is really the importance of experiential learning opportunities. We know that that knowledge, skills, attitudes really build on each other and they change over time. And experiential learning can be sort of the glue that allows that to happen. And that financial opportunities, when children or young people are learning about financial literacy, are important. And so providing guidance and feedback along with activities and information is really critical to supporting experiential learning opportunities. And so some of the things that we've learned is that, you know, the key components of experiential learning include having firsthand experiences in a safe environment, receiving guidance, opportunities to practice the decisions that perhaps they're going to encounter in 6 months or in a year, and opportunities for meaningful reflection. So it's not important to just have the opportunity to carry out to that activity, but to be able to sort of encourage to think about and reflect on that experience and think about maybe what they would do differently the next time around. And so this is just something that I bring up because I think this is really an area where there's so much synergy between the work that credit unions are doing and what, you know, we are encouraging and what, you know, what we're finding is really important. So we know that, you know, credit unions are among our leaders in advancing experiential learning opportunities, and many of you are working with schools, community organizations, and other partners to support that. And so just some examples that come to mind for me when I think about this is credit union branches and schools where young people are not only learning about financial education, but they are having the opportunity to open an account and save and build the habit of saving as part of their education. Reality fairs is another example where young people have the opportunity to anticipate the financial challenges that they're going to encounter and the difficult trade-offs that they're going to have to make when they reach adulthood. And as well as youth savings programs. I know that there are examples of programs out there that combine financial education with youth savings accounts or child savings accounts, where they get to not only sort of learn the importance of saving, but actually saving toward a goal and are encouraged to do so. So these are just some examples that come to mind of an area where I think there is a lot of synergy between the Bureau's efforts as well as credit unions. And you know, I highlight this and want to close on this slide because I think, you know, there are many other examples like this that perhaps I'm not aware of, or, you know, that you can just share with us. And from there, really look forward to hearing your thoughts and ideas about how we can work together and how we can collaborate. So with that, I will close and thank you.
Yannicka? No? Oh, was it? Really?
Why don't I move this?
Well, I just have a comment from our last meeting. Yannicka spoke about adult, education and protecting seniors and so forth. And I had shared with the council earlier that I took the tips that they had created for financial institutions and used that as a training tool for my staff. And since that time last year, we've actually called Adult Protective Services 3 times because the most empowering thing you said to us was that we aren't going to get in trouble for turning someone in. And that was wonderfully empowering, and I want to thank you, and I'm sure my 3 seniors want to thank you too.
Well, and we thank you.
All right, so council, do we have some comments regarding the presentation, and maybe share a little bit about what you're doing? I know several of you do reality fair. Several of you are in school systems already, so who'd like to go first? Greg?
Wow. At Wings outside of Minneapolis, we go on many levels, from partnering with Best Prep, which provides materials to the schools, to Junior Achievement, where we teach classes through the schools. We've hosted the Reality Fair. We also have a separate in-house training that we have for young adults, where there's an 8-hour course, and if they complete the course, if they pass the rigorous test at the end of the course, they're awarded $100 in their savings account. So we're involved in a number of levels, and I think that we have good community support, good school support, but we're not an area where it's required in the schools. One question I had for you was that on your guide for the policymakers, you had the 3 stages. Which of the three stages, or is there a particular building block that you see as the biggest stumbling point for getting it into policy, into the schools, so that really it becomes more of a formalized process?
I think it really depends on where, the particular community or setting that you're in. So I think it varies. I don't think there's one particular section where I'm hearing that people are struggling the most. I know with the laying the groundwork, one of the things that we hear most often is people really want to know how to make a really compelling case for why financial education is important, and in a way that resonates with the audiences that they're speaking to. So for that particular segment, I think that seems to be where we hear people want reach out to us and say, what research is out there? What can I cite to make the case? So I think it depends on where you are.
I would add that I think it's worth, the guide is fairly easy to look through, and what you'll see is others who have crossed these bridges before you, their names, and they'll be identified. And so you can also look to them as examples, and they may even share with you directly.
One of the ways that I see kids learn is through gamification. I know there are private firms that have models out there, but I really don't see something on a national scale that would be cheap for the school systems or something from the government model. Have y'all looked into producing an app or a computer game that would help people learn those lessons?
I think that's an interesting suggestion. It's maybe a stretch for us to be starting to invent video games here at the Bureau. I do think we have thought about some ideas around maybe providing guides for people using regular kinds of video games to sort of show how some of them might be useful at teaching financial lessons, again, in the vein of taking parents and kids where they already are and then giving them a way to put a financial frame around it. So that's one idea, but I like your suggestion, and we'll keep that in mind. Anything else?
Yeah, and I think I would also add, I know the Treasury, U.S. Treasury, they have an innovation fund that is doing some research looking at the effectiveness and sort of what makes these kinds of tools really successful. And so there are some examples there that we're really going to be looking to see what's working and what's effective. And based on that, if there's something that we can develop, that's something that we can certainly consider.
I do know of a product that Bankview offers called Money Island. We've used that actually in schools, and the kids really like it. The character they have to save his name is Stone Cold Broke, and and they have to make him not stone cold broke. But Bankview sells this product, and maybe have a conversation. I know you don't buy products, but you could look at the product itself. Anybody else have something to share or ask? Their thoughts, what you're doing. Who's doing reality fairs? I know someone was in here. All right, Patrick, you want to talk about a reality fair?
Well, we've been doing reality fairs at my credit union for many years. We do them stateside, we do them overseas in our overseas branches. It's been very successful. It's a very exciting program. I think one of the reasons we're able to have so many is because we host a lot of them. We provide all the materials. We provide our staff volunteers to perform the different tables, different professions, things like that, the counseling along the way for the Credit Union for Reality programs during the whole full day. It's been very successful. It's growing slowly. We discussed earlier some of the hurdles to getting the program into every school, but we're making progress in that front. It's been very successful. The kids love it. My daughter did it. So.
Do your employees enjoy it as well?
The employees enjoy it quite a bit. We send out the volunteer lists, and we never have trouble really filling the volunteers. 25, 30 volunteers we need to run a reality fair, and we never have trouble filling those.
Yes.
Bob Donnelly in Winston-Salem. We have been quite successful at the middle school level, and in a couple of counties, we have had great success at getting the math teachers to, in prep for when we come with a reality fair for the week or the 2 weeks prior to when we have the event scheduled at their school, they've incorporated the math techniques needed, balancing checkbooks, calculating interest, how do you calculate payments, various things, how that happens, so that when we come on site with a reality fair, they're then using the skill set that these 7th grade math teachers have taught in their classrooms. And so it ties it up in one kind of nice, neat project at the end, so that they're using something that they've been taught in the classroom in this fun event that teaches them what financial reality is sort of all about. And if you start this from scratch, you have to, in today's environment in the school systems with their budgets being financially strapped, you have to bring the product to them. You have to bring the materials and the personnel so that all they're doing is carving out the time slot in their day. And at the end of the day, for some of them, they see it as a respite from the normal teaching day, and it gives their children something else to do, and it is something that is needed. It's a skill set that is needed, and it needs to be all throughout, K through 12. And we find it extremely rewarding for both us, and when you see the light bulb go off in any number of kids' eyes about anything from that's what mom's always worried about, or that's what mom and dad are always arguing about, and that's why I can't have that pair of shoes this week. It helps in so many parts of family life. So it's extremely rewarding.
I'd like to piggyback on what you're saying there, Bob. Amy Nelson, Point West Credit Union. We've found that as Point West partners with a local nonprofit to provide the resources from the training materials and calculators and pencils to go through the financial literacy training, and those teachers do have that break or oftentimes participate themselves as well because it might be their first time.
That's correct.
Going through this financial literacy training. But for us, where we found a barrier, or I heard some of this resonating with what you were talking about and how maybe the Bureau can help support, is around the practitioners and increasing their capacity. And partly it's getting past that barrier of can they even schedule to carve out that time. And the nonprofit we work with has created an app where, be you a volunteer or a teacher, you can schedule time in the classroom. Everyone takes time for their phone, right? So it's another tool that they're able to utilize to take time then to provide those resources to their classroom. So technology now plays a role in ease of use, and I'm just wondering if there are tools or thoughts the Bureau has in just even reaching that one barrier of scheduling, because I know as we've gone through the years, that was the piece that was most challenging. Is there's certainly a want and there's certainly materials, but connecting the dots to just even schedule was a challenge. So are there tools or thoughts on that?
In terms of, I think the barrier that you highlight about there not being time, I think is a real one, and I don't know that anyone's really solved that particular challenge, but there are a range of resources out there to support teachers' own sort of personal development in finance. And so there are a number of examples that we provide and describe in the policy, in the resource guide that I mentioned earlier. But I think it comes down to providing really turnkey information to them right when they need it, as opposed to necessarily before they're ready for it. I think that that's a general principle for financial education, and I think it applies here also.
I'll add that we are updating the Policymaker Resource Guide on a regular basis. So if people have themselves crossed one of these bridges or solved one of these problems or have good resources in mind, we'd like to hear about them.
Thank you, Council, and thank you very much. Sunenu and Yannicka for your presentation. We very much appreciate it. The materials we have in our packet have a lot of really good resources in it, and I encourage everyone and all of you in the audience to read it. All right. So our second discussion of this afternoon will be from the Bureau staff on a set of recently released proposals that are under consideration by the Bureau. This summer, the Bureau released a set of proposals which would increase consumer protections as it pertains to third-party debt collectors and others covered under the Fair Debt Collections Practices Act, including many debt buyers. Debt collection is relevant to our business, and so we invited Bureau staff, Christian McPartland, the Senior Counsel in the Office of Regulations, and John McNamara, Acting Assistant Director in Markets Office, to provide an overview of the Bureau's recent proposal and to obtain council members' input. We're excited to have you here.
Thanks, Robin. First of all, I'd like to recap a few key points about the industry, some of which the director made in his opening remarks. First of all, there's over 6,000 firms in this space that on an annual basis may affect as many as 70 million consumers. We know that financial institutions and others collect debt, their own debt, themselves, or they may hire third-party debt collectors, or they may sell that debt to debt buyers, and those debt buyers in turn may resell that debt or hire their own third-party debt collectors. This is an area where the Bureau receives more complaints than any other financial services product or service. Most of those complaints are about debt collectors trying to collect the wrong amount from the wrong consumer or trying to collect debts that they cannot legally enforce. So the proposals under consideration, which Kristen's going to talk about in a few minutes, are designed to increase protections pertaining to third parties and others covered by the Fair Debt Collection Practices Act, as well as debt buyers. So the Bureau is interested in briefing the council members on the contours of the proposal, answer questions, and receive initial feedback from the credit union perspective. So to that end, my colleague, Kristen McPartland, will take a few minutes to walk you through key parts of the proposal under consideration. Kristen?
Great, thank you, John. Could I actually get the advance for the slides? Thank you. We'll just take a few minutes to go over some of the high-level proposals under consideration that are included in the outline. As mentioned before, that was published in late July of this year, and we just held the panel meeting a week ago, actually. So this is not going to be a comprehensive briefing. The outline, as you can imagine, has quite a lot of detail and discussion in there, but hopefully this will help provide an overview, and then we'll hand it back to John to ask some questions and look forward to your feedback. Just to start, we'll go over the rulemaking process and where we are. We started November 2013 when we issued an advance notice of proposed rulemaking, which asked a series of questions about the debt collection process overall and some of the consumer protection issues that it implicates. As I mentioned, we then went ahead and just issued the outline of proposals under consideration for the Small Business Regulatory Enforcement Fairness Act, which is somewhat unique to the Bureau, one of only a few federal agencies that engage in this process. And we just held the panel meeting to get feedback from those small business representatives. The next step is that after considering this briefer report, we'll go ahead and determine whether to go forward with a rulemaking. And if we do, we will then publish a proposed rule in the Federal Register and invite public comment. Then, as with all rules, the final rule would be issued with the specifics of what the regulation would require, and that would be published in the Federal Register and allow for an implementation period. The SBREFA process, sorry if I can get this working. Let me talk a little bit about what the outline itself entails. We release an outline of proposals that we are currently considering. So these are not proposed rules, nor do they contain draft rule language. So unlike, I'm sure you're familiar with reading rules that have been published, and there's usually preamble, specific regulatory language, oftentimes commentary. This is an outline that, in generally speaking, more plain language, will describe where the Bureau is at in our thinking today. It's meant to be a discussion piece so that we can solicit feedback from various stakeholders. The panel meeting that I mentioned before is then convened, along with the Small Business Administration and the Office of Management and Budget. Then within 60 days of convening the panel, will complete a report on the impact of the proposals under consideration on small businesses. And it's this feedback that we consider as we decide whether to move forward with a rule, and if so, what the rule will contain. So moving on to some of the highlights of the proposals under consideration. The first main one entails what we call debt substantiation, where we're considering clarifying the requirements of substantiation of debts. So under the proposals under consideration, a debt collector would be required to possess a reasonable basis for claims of indebtedness that are made to consumers. And specifically, in order to possess this reasonable basis, we've looked at 3 distinct times in the debt collection life cycle. The first time would be before making initial claims about the debt to a consumer. And here, we've described what would be essentially the steps you could take, although a collector would not be required to take those, in order to ensure that they have such reasonable basis to collect. Those steps would include obtaining and reviewing a list of fundamental information, obtaining a representation from the debt seller or the debt owner about the integrity of the information, and checking the information received for what we call warning signs. These are, of course, detailed in with much more specificity in the outline itself, but gives you an idea of some of the ways that we're looking to provide guidance on how collectors can have that reasonable basis before they begin making claims. The second point in time would be after receipt of a consumer dispute. And again, as I'm sure you're familiar with, sometimes consumers will come back to a collector and dispute the claim, saying, as to John's point, they're the wrong person, it's the wrong amount, they don't understand who's collecting, or some other concern about the debt itself. So here, the outline under the proposals under consideration envision outlining certain specified documents related to the type of dispute that a collector could review to then reobtain a reasonable basis to continue making claims. And of course, the flip side of that is if they couldn't obtain that reasonable basis, they should cease making those claims. The third point in time would be before making claims in a litigation filing. Here again, we are considering proposing certain documents that a collector should review before making those claims in the litigation process. This is related to our information transfer and forwarding requirements, which also go to the integrity of the claims about which are being made to the consumers. Here, we're considering a requirement to pass on certain information when returning a debt to the debt owner or selling the debt to a subsequent debt buyer. That information would include information related to FDCPA rights, such as dispute status, what we call confirmed consumer contact status, which goes to communications. I'll speak about that in just a few minutes. And any inconvenient time, place, or manner information about contacts to consumers. It could also include other federal law information, such as interest rate limitations under the SCRA, certain federal student loan information, such as discharge or rehabilitation. Also may include whether a consumer has stated a language preference or asserted an oral cease communication request to the collector. Likewise, we have information forwarding requirements that we're considering, and these would apply when a collector, or after a collector returns or sells a debt. So here, a more limited list of information could be required to be passed on if that information came to the collector even once they had essentially passed on the debt. These are, of course, detailed again in some of the appendices to the outline. Another aspect that we're looking at is increasing consumer awareness and understanding of both their debt under collection and the debt collection process overall. Currently, validation notices are in use by most collectors. It's typically the letter that's sent within 5 days of the first communication with a consumer. But that may include, at this time, relatively limited information that's set by statute. So we're looking at clarifying that validation notices should include enhanced and additional information to help the consumer recognize the debt in front of them. This information is about the debt, including the name of the creditor at the time of default, the name of the current creditor, the amount owed at default, the amount currently owed, as well as an itemization of interest, fees, payments, and credits since default. It also would include information about the consumer's rights, including the right to dispute the debt, with more detail about how to go about that. And we're thinking about including what we call a tear-off at the bottom of the letter. That would facilitate the exercise of consumer rights with options like "this is not my debt" or "the amount is wrong," So very plain language ways for a consumer to review the debt. Hopefully they recognize it based on the additional information, but if not, they have an easy and accessible way to respond. We're also considering providing what we call a statement of rights. And this would be a standard letter with plain language explanations of some consumer federal rights, including, for instance, the right to dispute a debt, the right to stop communications or limit those communications, the right not to be harassed or abused, the right not to have your debt disclosed to third parties. We're currently considering issuing model documents that would satisfy the rule's content, and the use of these would not be mandatory, but we do, of course, expect that many people would want to use them. And I have here the current potential model validation notice, which is, I apologize, somewhat hard to see. We do expect it will be much more usable for consumers themselves. But if you take a quick look, you can see that it's divided in some ways into 3 parts. The first being more information about the debt with certain itemization, then a section about dispute and some of your rights, and then the tear-off that I referenced before at the bottom. We also have the potential statement of rights here, which is, as I said, a standard form that could be used to describe some of the federal rights that apply to the debt collection process. Now, these are not final yet. These have been subject to some testing. We continue to look at them and consider the feedback on these forms and the content. But if we did go forward with this, we would expect to publish a model form as part of the rulemaking. A couple other disclosures of note. We are considering a litigation disclosure, which would require collectors to provide in communications in which they represent an intent to sue, a litigation disclosure informing the consumer that the collection agency intends to sue, that a court could rule against the consumer if he or she fails to defend, and additional information about litigation, including contacts for legal services programs that are available on the Bureau's website. So we envision this to be a fairly short and succinct disclosure, but that would provide some information to consumers about litigation. We're also looking at a time-barred debt disclosure. Again, time-barred debt being the collection of debts that are out of the statute of limitations and therefore typically either cannot be sued upon in state court or it would be an affirmative defense to such a lawsuit if it were brought. Here, we're thinking about requiring that collectors disclose that the collector cannot sue to recover the debt, and if the debt is obsolete, that it cannot generally appear on a credit report. So obsolete, just as a very general statement, would be over 7 years. Of course, there are exceptions to that too, but we are considering that requiring collectors who do collect on time-barred debt to waive the right to sue on revived debt because it is so complicated to disclose to consumers that making a partial payment or affirming a debt in writing can, in some states and some situations, revive the debt. And subsequent collectors would be prohibited from suing on a debt for which an earlier collector provided the time-barred debt disclosure. So in other words, if a consumer received the time-barred debt disclosure once, they would be able to rely on that even if the debt moved on to a subsequent collector. Moving along, and I realize I'm going through this quite quickly, but third major bucket is communication practices. And here again, there's much more detail in the outline. But just to hit a couple of the highlights, we are looking at contact frequency proposals, and these would be contact caps on both contacts themselves and attempts to contact consumers. What we are currently considering is a limit of 3 attempts per method of contact per week per account. So that would be by phone number, for instance, by address, email address, and so on. But with a total overall cap of 6 attempts per week. So for instance, you can make 2 attempts to a certain phone number, 2 attempts to another phone number, perhaps a mailing, but all subject to this overall cap of 6 per week. Now, these are the contact caps excuse me, that we're envisioning before the collector has what we call confirmed consumer contact. That would be when the collector has reached the person that they believe to be the debtor on the account. The idea, of course, being that before you know how to reach the person, it may be necessary to make slightly more contact attempts, but after you know how to reach the person, it may be reasonable to have somewhat fewer. So post-confirmed consumer contact, the limit would be 2 attempts per method of contact, again, per account per week, with 3 total attempts overall and 1 live conversation per week. As part of this, we're also looking at providing clarity around voicemail messages and when and how those can be left for consumers. Currently, many different voicemail messages are in use by collectors, and some collectors actually don't use voicemail messages because of concerns about litigation exposure. So the Bureau is considering being clear that we would permit certain limited contact voicemail and other messages for consumers, and that these messages would not communicate information about the debt or constitute FDCPA communications if they convey only 3 pieces of information: the individual debt collector's name, the consumer's name, and a toll-free number to reach the collector back. We do think that with the voicemail, being clear on the voicemails will work well in conjunction with the contact caps, since attempts could then result in a voicemail rather than either leaving potentially a confusing voicemail or no voicemail at all today, as may be. Finally, we're also looking at some restrictions applying to the collection of decedent debt. Here, we're considering a waiting period after a consumer's death for communication about the collection of the decedent's debt. We're looking at 30 days. We're also soliciting comment on 60 days as a waiting period. Just a couple more things on communications. We're also looking at some clarifications around the time, place, and manner of communications in collection. One would be communications using newer technologies. Here, we would clarify that whether communication is sent at an unusual or inconvenient time is determined by the time at which the communication generally is available for the consumer to receive it. So, for example, if you send an email at 9 a.m. in the morning, it would be presumed to be available at that time, and would not, and even if the consumer opened it somewhat later, it would still be that 9 a.m. that determines whether or not it's sent at a convenient time. On presumptively inconvenient places, we're looking at considering a presumption that medical facilities, places of worship, places of burial or grieving, and child care facilities are presumptively inconvenient for debt collection contacts. Also, another detail, we're looking at employer email, and here we would consider prohibiting collectors from using an email address that they know or should know is the consumer's workplace email for debt collection communications, unless, of course, the consumer consents directly to the debt collector. Finally, a few notes on consumer consent. Again, this is obviously quite a complicated topic and one with more detail, but just to go over a few highlights. We're considering clarifying the parameters of obtaining consent from consumers for communications that otherwise would be restricted by the FDCPA. And some of those aspects would be direct consent, requirement that consent be obtained directly from a consumer by the collector, whether orally or in writing. Disclosure requirement to disclose to the consumer orally in writing what they are in fact consenting to in terms of communication. And memorialization, so a requirement to memorialize the consent. If it's in writing, it could be keeping that. If it's oral, it could include a recording of the conversation or a notation in the account file. So I realize it's a lot of information. As I said, those really are just kind of the highlights of this, but we hope that it gives you some background so that I can turn it over to John to solicit some information.
Great, thank you, Kristen. We would like to hear the council's initial feedback, and to that end, we have a number of discussion questions that we'd like to pose to the council, if I may, Robin? Thanks. So, what type of information do you think consumers need to know about their debts, the debt collection process, and their rights in dealing with a debt collector? That's the first discussion question.
I'll start. I think that the idea of presenting, I owed this debt to blank for this dollar amount blank, I took out this date on this date blank, I owe this much interest. All those are questions. Usually they just get a letter saying, you owe me $5,372 and pay up now. So having a detail, I think that is extremely important for them to know. And I do agree with the comments that if they had more detail, perhaps that will trigger, yes, I do owe that debt, or I've never had an account with Sears. What do you mean?
Great, thank you.
Along that same line, in that notice, do certain charges or interest, do they continue to accrue beyond the point of the notification? So typically, the interest didn't stop, but I owe this much at this point, but what happens in 30, 60, 90 days from now, to give the borrower an idea of what the liability could be?
I was just going to add that the obligated borrowers' names might be beneficial in that communication as well, in the event that you're dealing with death or divorce.
On the potential validation notice, the rip-off portion at the bottom, where you have reasons for a dispute, it would be helpful to have an explanation. Back to Tom's point, I knew I owed $100, but I didn't know the interest. If the person checks the box on a dispute on the debt, the dollar amount of the debt, you don't know what their dispute is. So if you could have some clarification, it could reduce the number of contacts needed.
So what I heard was some clarification on whether the balance confusion is pre or post default.
From the consumer's perspective, what they think they owe would help the person trying to collect the debt on how much they agree to, how much they're disputing.
Great, thank you.
You know, one of the things that, in speaking to some of the collectors, one of the things that keeps surfacing is that a lot of the times the members are not really aware about the implications of not making the payment and how that impacts their credit score, their access to future financial products. You talked about statement of rights, and so I was thinking there could be an opportunity for something along the lines that as know before you default. That gives them an idea about what the impacts would be and the future consequences on their ability to obtain credit.
Sarah?
Yes, I mentioned earlier we have a credit counseling department under our umbrella. One thing that I think would be helpful would be to include, if it's a third-party debt collector, when the debt was acquired. We've seen credit reports where a borrower may have debt that was 4 or 5 years old, but when it was purchased from a third-party debt collector, the debt shows on the credit report as being a newer or more recent debt. So it may have been something they could have settled earlier, or it looks more recent than it actually is and hurts their credit more than necessary.
I have a question on medical debt. For what's on there for the collections. Would it be possible for them to put, you know, it comes from such and such hospital or such and such doctor and date of treatment? I don't know, because I think that would help, because I see a lot of credit reports with a lot of medical debt, you know, so having more detail, it just seems like it's, well, I'm in dispute because I didn't want to pay my copay. Having a path to kind of, this is for what that is, would I think be very helpful. I don't know what kind of information, I don't know how medical debt is reported in that, so just kind of a question.
Thank you, Robin. That's helpful. And certainly date of service is pretty common. Sometimes other information may have HIPAA constraints.
Yeah, that's something that we're considering. We appreciate that. There's a bit of a space issue in terms of what information can get on the validation notice, so we're trying to balance all the various pieces that could be on there versus what would be most useful to people. But you make an excellent point about medical debt and how it can be somewhat unique in the recognition process for consumers.
Could it be something after they say maybe check off, I dispute this, then they have to prove, you know, showing that in proof if it couldn't be all done in one fell swoop, you know, the validation that that debt really is owed?
So one of the things that I didn't touch on as much here is the requirements for a collector after a dispute has been placed in by a consumer, and that is one of the things that we're looking at, which is what is the collector's responsibility to verify the debt.
Patrick, you had a comment?
Yes, in addition, as far as after a dispute and verifying the debt, I think consideration ought to be given to providing a copy of the note. It shows the date of the transaction, it shows what it's for, it shows the signature. I know when collecting as an attorney, I always required a copy of the note and in accounting, but the note would go a long way. I mean, you have to be careful not to be sending a note right away because they may not be the right person, but once a dispute has been entered into, then I think the note, some consideration should be given to providing the note.
Great, thank you.
Actually, that's a great segue into the next question, Patrick. If and when you place accounts with third-party collection agencies, what information do you provide those firms?
Yes, we provide them with the last known address, the name, obviously, social security number, the amount of the original obligation, the amount that's owing, last paid date. That's typically what when we send out to third parties.
We also provide the third-party collector the reason for the delinquency, and also what you had mentioned, and we also, the contact information, and also we tell them what acceptable terms we would take.
I think the same as most everybody else. Member name, social, date of birth, address, phone numbers, last known employer, email, account type, account number, original loan date, original loan amount, interest rate, charge-off date, principal amount, interest amount, repo fees, if any, and cosigner information. So pretty much what you were recommending.
Tom?
We provide a cover sheet that summarizes that information, but we also give them a copy of the application and the loan agreement as well. Since most of those are digital now, so we just get a copy of the file and attach it and send it right off the bat.
Great, thank you.
Katie had one.
We provide all the same information, but additionally 2 different addresses, both the physical and the mailing address, because sometimes that can be different.
We also provide the collection history to them.
Great. Next question. How frequently do credit unions utilize third-party debt collectors to collect on outstanding obligations?
At our credit union, we only turn it over to a third party after we've exhausted all efforts. So usually it's after charge-off, and even further than that. Usually we'll spend at least a minimum of 60 to 90 days collecting after it's been charged off, and sometimes even beyond that, before we would turn it over to a third party to collect the debt. We don't sell the debts, but we do engage agencies at times to assist with those debts. But we like to be involved as long as we can, because we believe, obviously, the relationship that we have will be more effective, and obviously we can control more that interaction with the consumer.
Yes, we use a third-party collector also when we charge off, but also for credit cards, we use a third party when they're 5 days delinquent up to 25 days delinquent, so they can contact the member, because we don't have the bandwidth to contact those members. And then they send those accounts back to the credit union, and then we then work them until they're charged off.
So I know my colleagues are probably a little exhausted about hearing about our relationship, local government, with State Employees Credit Union. But they do all of our collecting for us. And we don't consider them a third party. They are our agent. So we're probably more in the first party context. But they collect up until the point in which they charge off the loan, at which time they then send over the loan file to us, and we try to recoup whatever we can. I was telling another colleague that we are in the process of trying to decide jointly whether or not we even want to continue seeking judgments at all, just because we're finding out that the soft costs are becoming much more expensive than the benefits that we're reaping from actually getting some of the money back. And I will also say that we have actually never collected on a judgment. Yeah. So I say that all to say that to give you some insight into credit unions and what our mindset is. We're not like these, third-party debt collecting shops. We really are out to, look out for the best interests of our members. Now, we obviously have to balance that with the fact that while we're not profit, we're not in the business of losing money, and I make sure I make that clear to my folks. But just some insight into kind of the difference, the distinction between credit unions and oftentimes banks.
That nicely anticipated my last question, and that is, do collectors typically collect in the credit union's name or in the name of the debt collector?
We turn ours over after 120 days, which is the charge-off point, and from that point, they collect under their name, not ours.
Carrie O'Connor, we also always have them collect in our name. So they may say that I'm a collection agency, but I'm collecting on behalf of the credit union. So actually, I apologize.
We do the same. They collect, after charge-off, we send them out and they collect in their name.
I think one council member mentioned that they might use a third party when the account was delinquent by, say, 5 days. Is that typically done in the name of the credit union or in the name of the debt collector?
Yes, that is done in the name of the credit union, and the reason we do that is because we want our members to still be able to use their credit card, and so yes, it is in our name.
Great, thank you.
Is that all your questions?
Yes, thank you.
Thank you very much.
Other things people want to discuss about that? I'm sorry, do you have more?
Tom?
Yeah, I have a question for you regarding consents. Majority of our members have given us e-notification consent. They've gone through the process to accept e-statements and e-notifications. Would that consent be sufficient in your mind for the collector to use those e-version methods to approach the member? And conversely, if they did not give us e-consent, and we've been doing paper-based, should they be prohibited from doing an email or e-notification unless and until they then got that consent?
That is a great question, and one that we're still working through. So consent is obviously a very complicated topic. Now, in the FDCPA, one of the provisions talks about consent given directly to the collector, so that is some statutory language that we bear in mind in terms of transferring consent from one party to another. There can also be situations in which transferring consent is actually not particularly consumer friendly. There are some situations in which it may be as well. So at this point, because these are proposals under consideration, we've outlined some of these broad ideas that we are looking at, and we are certainly concerned about bringing some clarity to consent and what the parameters will be. But I don't know that at this moment I can give you a very clear answer to your specific question.
Any further questions, Dave?
Quick question on the time-barred portion of the validation. And let me say this. My former life, I was a civil litigator. One thing that annoyed me to no end was plaintiffs' attorneys filing lawsuits that they knew were barred by the statute of limitations. I think it's unethical as an attorney to do that. So I understand that. I wonder, though, whether or not is a bridge too far to also then require the collector to put in the notice that their claim is time-barred when they have the supporting documentation that makes clear that the debt is what it is, it's the right amount, right person, so far.
But time-barred.
Time-barred. You might as well just send them a notice saying the debt is canceled.
Well, the disclosure does just say that it's essentially time-barred, that it can't be sued on in court. So I don't think it's going so far as to say the debt is canceled. Obviously, you can still make a payment request for it, and the validation notice does envision that. But I take your point. I mean, we certainly hear a lot of feedback on this topic from all sides, to be honest. So it's definitely a complicated issue. It's one that we can continue to look at with a great deal of thought and consideration. The director is sitting here and can attest to that. But where we are right now is looking at a disclosure so that consumers will know what the status is at the time the collection effort is made. And we think that disclosure can be relatively straightforward and understandable for consumers.
What's the argument that you would make that, I mean, we have had discussions of this, but I'd like to hear how you frame it. If the debt is time barred and the collector knows it to be time barred, for them to send out a notice saying, we'd like you to pay this debt, and not to say that they know it to be time barred, what's the argument as to why that's appropriate or ethical? Or, I mean, you said if they filed a lawsuit and pretended like they didn't know it,
Right.
you found that unethical. Why is this better?
And I understand it does seem like I'm talking out of both sides of my mouth, but I would caveat the time barred situation where it is indeed the case that the debt is what it is. So they owe the debt in terms of the amount, individual. I'm just wondering whether or not to actually affirmatively say that the claim is potentially time barred. Is that something that's going a little too far?
I actually think the much more difficult situation, which will come up fairly commonly too, is it's not entirely clear whether it's time barred, you know, and if it, and or the collector will want to come up with some plausible rationalization of themselves that we don't know for sure that it's time barred. But
That's a good point too, Director.
if you know it to be time barred, you know, it feels like you know that, you're more knowledgeable, the consumer's not very knowledgeable. For them to get a collection request and not to have you state what you know, it's not obvious why the collector should have the right to get, or why anybody should think that's fair. I mean, this is not to answer the question. We haven't answered the question. We're thinking about it. I'm just trying to probe and understand why you think it should be justified to be able to.
Debt is owed.
And
And,
it's been owed
and-
during a period
sure.
that the law allows to collect it, and now the law says it can't be collected through the means of a lawsuit. And then the question is how important or how justified is it to say it should still be collected even though you can't use the means of a lawsuit? When frankly, you know, I think we all have a sense that many times this communication will carry with it without saying so the implicit threat that we're going to take all legal steps to collect it, and you know, that would might seem to be implicit in the letter, particularly if it comes, as many debt collection letters do come, from a law firm. So
I just don't see what the impetus would be for the member at that point in time to make any payment.
it would be, the impetus would be the same impetus they would otherwise have. I mean, actually what you're saying is the impetus for them to pay at that point would be that they know they owe the debt. They know, and people do feel this in their
Yes.
mind, that they have some moral obligation to pay the debt, but they're now aware that they can't be sued for the debt.
Right.
If you think they're never going to pay in that situation, then what you're saying effectively is the collector ought to be able to press them to pay the debt and expect they'll only ever pay it if they're under the misimpression that they can legally be sued for the debt. I mean, it's just not obvious to me why that's a great idea or
Now,
why
there's-
that's
Now,
justified.
Director, there's a difference between, I do not agree, as I said initially, a lawsuit should not be filed. That's unethical. You cannot do that. You should not be able to do that. So there's a difference between, I think, what you're saying and then the debt collector then actually going out and filing what is then a frivolous lawsuit.
You know, obviously, you shouldn't file a lawsuit you know doesn't have a justification.
Exactly.
Just as you shouldn't file a lawsuit against person A for a debt you know to be against person B. What I'm trying to understand is, if you think that if the consumer actually knew that it's time barred, they would never pay it, then you must be assuming that if they don't know it's time barred, even though it is, and they could have been told that by the collector, they would pay it solely because of the misimpression that they aren't aware that it is time barred. That's, at least implicitly, somewhat deceptive, right? I mean, in fact, there are people who pay their debts, even though they're time barred. I mean, Abraham Lincoln was famous for the fact that the store that he helped own and that collapsed, he spent years paying the debts. He was a lawyer. He knew after a while they were time barred. He felt the moral obligation to pay the debts. But the notion, and so people will do that, and even if you told them it's time barred, some people will pay the debts. If you think the only reason, if you think that they would never pay a debt unless they thought they could be sued on it is the only reason they would ever pay a debt, then why you should be able to withhold the fact that they can't be sued on it, and then they would pay the debt under that misimpression when you could have cleared that up. This is not, I'm not speaking for the Bureau here, this is a preliminary process,
I
et cetera.
understand. Point
But
of
I'm just trying to
observation.
probe the argument, because
No,
I
I
think there's
understand.
assumptions there that I'm not clear to me what we should think of those assumptions, that's all. Yeah.
Understood.
Part of this process.
All
right.
By the way, this is not necessarily saying what could be said, which is you shouldn't even be able to contact them if you know you can't legally enforce the debt. I think with the proposal here, at least, or the framework, suggests that you can certainly contact them, but you ought to give them the full information that you have.
That is true, sir.
Yeah.
Point well taken.
Quick question, comment on that. I think if we're telling borrowers that we can't attach their can't sue them, can't attach their paycheck, can't put a judgment against their real property, so effectively, there's no need for them to pay it because we can't enforce our rights. You'll see more creditors filing a 1099 forgiveness of debt and letting the IRS collect it for us.
That's true, and all of these things, like whether people can't be contacted, then the debt collector will more likely jump immediately to filing a lawsuit, et cetera. There are lots of, one of the things the team has been grappling with and teaching a lot of us who aren't as knowledgeable as they are in this, is there are a lot of, bank shot ramifications of various things that, that aren't obvious at first, but when you start to think about them, may not be so good. So that's definitely worth considering, thinking about.
All right, we're going to wrap up, and Bob, you had a comment? No? All right. All right. Patrick? You're okay? All right. Well, that was certainly a good conversation, and I hope that we gave you some good information that you can go back for that. So, are we going to wrap up then? Okay. All right. So, I'm going to turn this back over to Delicia, and thank you. No? Did I just wrap? Okay. Sorry, I didn't follow my correct cue. All right, it's past 5. It's time to go, and we're going to wrap up our public session. Thank you very much, public, for showing up and coming to listen. Great conversation, and everybody have a safe journey home. Thank you.